in fact, will stay then with Parliament. Members have voted to adopt the Electoral Amendment Bill. It's despite several groups calling for the proposed law to be rejected, primarily due to the onerous requirements made on independent candidates in participating in elections. We're joined by One Movement leader, Mmusi Maimane. Mr. Maimane, good evening to you. Thanks for your time. You've been one of those that has been advocating at least against the adoption of the amendment bill in its current state. Some of those cries seem to have fallen on deaf ears.
Good evening, and good evening to fellow South Africans. You know, when I launched Build One South Africa, it was precisely because I anticipated that this is a parliament of members of parliament who don't really want to be accountable to the people of this country. They certainly want to make life hard for constituencies to be able to speak and hold their public representatives accountable. And ultimately, the bill that they've proposed and passed today will make it impossible for any independent to stand and succeed, really. And furthermore, it's just another breeding ground for a different form of state capture to occur when you think about one-party dominance and parties being able to be the ultimate authority rather than citizens being the people who are in charge.
The argument that has been made by the Home Affairs Committee that, of course, worked extensively on this bill is that they have accommodated some of the changes from the public. They've reduced that threshold in terms of the number of signatures originally required for independent candidates to contest. Do you think that they've gone far enough?
Certainly not. I think that even the way they've gone about it is malicious compliance to the Constitution, to the Constitutional Court ruling, because what is now in fact happened is that they've, even though they've reduced that threshold is still high. It's when you compare it to a political party, there are different places for people to be able to approach this matter. And furthermore, the cost of registration, ultimately the failure to reform to a constituency-based model. These are the great difficulties that I think any citizen who wants to have public representation will have to overcome. So to me, whilst they've done some superficial amendments, in the main, I think Parliament could be held up for contempt of court. And I'm not certain that the President can in good conscience sign this into law, because I think it will not pass constitutional muster, because it has really maliciously complied with the order that was given by Judge Madlanga.
While we may debate and argue about the amendments in the bill, and it's a point that Parliament has been making for a long time, that the Constitutional Court effectively did not tell them how to implement the changes, but simply said they should, and that it would be an overreach to get into the details of how they should go about doing that. Do you think that going forward, we're now going to face a situation where the constitutionality of what has been passed and possibly may be signed into law will be contested, and we have to think about the long-term ramifications of that in the context of the 2024 elections that are around the corner?
Undeniably. I happen to think in this instance, this is, by the way, not a matter that has emerged only in 2020. President Mandela raised this particular issue of saying we've got to amend the electoral law. President Mbeki also understood its implications, and ultimately President Kgalema Motlanthe raised it in a high-level panel report to say we must amend this issue. So this has been stalling since the dawn of democracy. The great difficulty here, Kathy, is that in fact the way Parliament works is set up for constituencies. Members of Parliament sit on Tuesday, Wednesday, Thursday, Friday, Saturday, Sunday, and Monday. They are meant to be at their constituencies. Now, if you don't give the enabling legislation to make sure that that is meaningful, it means that they run party offices in their communities instead of servicing the people. So to me, the point that you make, which is that the Constitutional Court on one end could not prescribe what Parliament was due, it made a ruling that made it impossible for you, once you consider that ruling, to not consider the rest of what the law in fact was intended to do. And therefore, all the Concord said is that go back to the principles that were established in the drafting of the Constitution, so that accountability is always with the people. But when you have a parliament that is no longer caring about its people, even that slight clause was truly a gateway to open the rest. Otherwise, the Minister of Home Affairs should have not have set up the Ministerial Advisory Committee, which advised the same parliament that there were two options here. Either you could minimalistically comply, which is what they've done, or actually overhaul the system, which is what the law in fact required. So I really believe the people of South Africa today were put second, and that's why as Build One South Africa, I can assure you, we are going back to communities to say, bring us your best candidates so that we can go out and challenge this matter, both inside Parliament by making sure that the best representatives come from the people of this country.
All right, Mmusi Maimane, we'll leave it there for tonight. As you heard, he's the leader there of One South Africa movement.